Hello and welcome to I and a Student. I and a Student is a segment for students who opt their topic, do their research and present them in front of our audience. So today we have Ms. Tanu Jaiswal who is going to enlighten us on her research topic, that is an overview of the Special Marriage Act 1954, a landmark in secular matrimonial law. So let's welcome Tanu Jaiswal.
Sincere, heartfelt greetings to everyone. My name is Tanu Jaiswal and I will be taking you through an important topic of discussion, that is Special Marriage Act. Special Marriage Act being a landmark secular matrimonial law. Before stepping directly into this act, let's startingly describe about the topic we will be covering under this act. Firstly, we will be speaking about the introduction, followed by the history behind this act, the procedure, the conditions and the objective, purpose, its applicability, as well as this act speaks about the void and voidable marriage, followed by the divorce, etc. So before starting with this act, let me first say you, India is a diverse country with its religion, language, tradition, culture and many more things. So in India, basically two types of marriage prevails. That is the traditional marriage, on the other hand that is the special marriage. Today's topic we will be discussing on, we will be focusing on the Special Marriage Act. Traditional marriage, which are governed by the personal laws under which the people of same faith decides to tie a knot under this act. Second is the Special Marriage Act. Under Special Marriage Act, it operates and applies to the individual who do not belong to the same caste, religion, creed or even the nationality for that matter, so long as one have to be an Indian origin. That's only the fundamental prerequisite purpose for registration under the Special Marriage Act of 1954. Hence we have got an introduction about this act. Let's further move to the historical background. Before going deep into this act of 1954, the discussion about this act, how it came into the existence, let us be known about this act. During the British era, people were so confirmed with the idea of caste, they did not wanted to marry outside the caste. So, during the year of 1872, the British scholar decided to introduce a change in the personal law system. They had enacted the Marriage Act of 1872, which allowed marriage outside the religion personal law, which was limited and not widely used. With the independence of 1947, there was a growing need for law that accommodate marriage between the individuals of different religion, caste background. Therefore, the Special Marriage Act of 1954 came into the picture and was drafted to address the need, aiming to promote secularism and individual freedom in the marriage. Let's know the objective and the purpose of this act, why this act needs to be come into the picture. The objective behind this act, it aims to provide special form of marriage regardless to the faith followed by either the party. The beauty of this act that it aims to facilitate interreligious, intercaste marriage by providing a legal framework and allows the individual without converting the religion of their partner. So we can conclude that the partners did not need to change their religion under this act. They can follow their own faith, they can follow their own religion staying under one roof. This act is designed to promote secularism, individual freedom of choice in marriage, social harmony and enabling the marriages based on mutual consent without any religious barriers. Let's understand the applicability. In which areas does it apply? The Special Marriage Act of 1954 is applicable and extend to all Indian states as well as to the Indian national living in other countries as well. The individuals of diverse faiths such as Muslim, Hindu, Parsi, Sikh, Christians can marry under this act. This act applies not only to the interreligious, intercaste or love marriages, but also it provides a platform for the interfaith marriages where the people can register under this act. What are the essential conditions required under this act to consider this marriage to be a valid marriage? Chapter 2, Section 4 of this Act speaks about the essential condition. The first essential condition under this Act, neither the party must having a living spouse. If either having been previously married, it is crucial that the prior marriage is legally dissolved before seeking a marriage under this Act. The second essential condition under this Act, both the individual must be capable, freely and fully consented. If the consent has been obtained from undue influence, fraud, misrepresentation or any kind of glitch, the marriage will be considered as invalid marriage. Third and the essential condition is the age factor. The female partner must be 18 and above and the male should be 21 and above. Fourth, marriage cannot be solemnized if the parties are within the prohibited degree of relationship. What do we mean by prohibited degree of relationship? Prohibited degree of relationship means that the parties should not be subinda to each other. Subinda, but it means that the parties shouldn't have a close relationship with each other. Let's understand the procedure need to be followed in order to tie a knot under this act. So section 5 of this act speaks about the procedure of this act. When above all the condition has been fulfilled by the parties, has followed the procedure prescribed. No religious ceremony is required under this act. The marriage is solemnized by the marriage officer appointed by the government and concerned parties to the marriage and give a notice to the marriage officer in a prescribed manner. The marriage officer shall enter the information in the register maintained by him. The marriage officer will issue a public notice to filing an objection. The marriage is to be performed after the 30 days of the expiry of the public notice and before the expiry of 2 months of this notice issue. A declaration form is specified have to be signed by the applicant along with the 3 witnesses. The marriage officer shall be satisfied with all the conditions prescribed and the procedure to be followed. He will issue a certificate to the marriage. Now let's discuss what is the void marriage and voidable marriage under this act. Void marriage under section 24 of this act. Any marriage solemnized under this act shall be declared to be null and void if any of this condition has been breached. For example, if the parties are marrying under the prohibited degree of relationship, the marriage will be considered to be a void marriage. Voidable marriage. A marriage under this act shall be voidable and may be annulled by the degree of nullity. First, if the marriage has not been consummated owing a willful refusal of the respondent to consummate the marriage. Second, the respondent was at the time of the marriage pregnant by some other person rather than the petitioner. The consent of either of the parties of the marriage was obtained through coercion or fraud. Then the marriage will be considered to be a voidable marriage. Now let's speak about the divorce. This act also provides the ground for divorce as well. Parties may belong to different religion when they perform the marriage under this act, but they will have the similar ground for divorce as mentioned in other personal laws as well. The first ground for divorce will be adultery. Adultery, it is a matrimonial offense in which the married person and a person of the opposite gender other than the wife have a consensual sexual intercourse. Second is desertion. The respondent, respondent must have deserted the petitioner without cause at least for 2 years before the petition was submitted. The third ground is imprisonment. If the respondent is subjected to imprisonment for 7 years or more than 7 years, it may be also be a ground for divorce. Next is cruelty. The respondent has to cause any kind of mental or physical cruelty to the petitioner, or any kind of apprehension has been made by the petitioner that any time the harm will be caused, there is a ground for divorce under this act. Unsoundness of mind. If the respondent is unsound, which is incurable, will be also be the ground for divorce. Leprosy, and the last is not heard has been alive. The respondent has not been heard by the people who are closely related to the respondent for 7 years. Then it has been presumed that the person is dead. There is also ground for divorce under section 28 by mutual consent. The parties can mutually give the consent for divorce under this act. Now the question arises, can the divorced person can remarry? So the answer is yes, the divorced person can remarry under this act, but the prior marriage should be legally dissolved. That's the overview of this act. In the nutshell, Special Marriage Act of 1954 show us that love can arise above religion, caste, community. It's all about choosing your partner wisely and freely. The act speaks about the marriage beyond the boundaries. That's it.
Tanu, thank you very much. It was a nice overview of the entire Special Marriage Act, and we are happy that the students are picking up these kind of topics to speak. So thank you very much. A small token from Hammurabi to you.